Good morning, everyone. I'm speaking to you from Geneva, where it's a very rainy day outside. Welcome to the Shanghai and Beijing panel of the BIICL WTO Conference. My name is Joanne Crawford. I recently retired from the WTO, but prior to retirement, I worked for a number of years in the Secretariat, most recently as a councillor in the Trade Policy Review Division. So please bear with me if I'm not adept at using Zoom as others. Our session today will deal with digital technology and trade, a topic which is, of course, of current and growing significance. Indeed, in 2018, the WTO dedicated its flagship annual World Trade Report to how digital technologies are transforming global commerce by reducing trade costs and expanding trade, especially in services. We are very fortunate to have three experts with us today to explore this topic. Professor Larry Kong is Dean of the School of International Law, China University of Political Science, and has been a full professor of law since 2002. He is also the editor-in-chief of the Chinese Journal of Global Governance. He specializes in international economic law, WTO law, and China issues, and has authored a number of articles, international journals, and books on international trade topics. Lee Tuthill has worked at the WTO since 1990. She is an expert on telecommunications, ICT, and ICT-enabled services, electronic commerce, and Mode 1. She covers the WTO e-commerce discussions and keeps abreast on how ICT and e-commerce developments relate to the GATS and other WTO agreements. And last but not least, Professor Henry Gao is Associate Professor of Law at Singapore Management University. Henry has law degrees from 3 continents and started his career as the first Chinese lawyer at the WTO Secretariat. He has widely published on issues relating to China and WTO and has advised many national governments as well as the WTO, World Bank, Asian Development Bank, APEC, and ASEAN on trade issues. So let's open the panel first with Professor Larry Kong, who will discuss the Phase 1 agreement and its impact on China-US relations and a revival of the WTO. Larry, you have the floor.
Professor Kong, you are muted. You are still muted.
Yeah. Sorry for this. Thank you very much. I'm very pleased to sit on this prestigious panel. Actually, I'm not talking about digital trade. Actually, I possibly should sit on the previous panel, which is talking about WTO and the China-US relations. But nevertheless, I will share my views on this in this regard. Indeed, as we have known, the WTO has encountered unprecedented challenge. Not only has the WTO been incompetent as a forum for trade negotiation, but appellate body failed to function due to the failure to appoint its members by the DSB. More and more disputes arising out of the uncertain trade tensions among members, and more disputes will become pending everlastingly so long as the losing member opts to lodge an appeal. Thus, the dispute settlement function will crash, and no rule breaker will be subject to discipline, let alone punishment. Moreover, a formidable number of restrictive measures were imposed, largely without prior endorsement of DSB, upon a larger portion of the world trade, which valued something like 700 billion US dollars in 2019 alone. These trade measures, which are apparently inconsistent with the WTO, will not be addressed by the failing dispute settlement mechanism. The order for which the WTO was designed has in a way crashed, and the freer trade has become a luxury. As the COVID-19 pandemic is still inflicting the world, its aggregated effect has cast global trade in the darkest shadow. And the future of the WTO has become even more uncertain. Against this backdrop, one has to consider the underlying issue pertinent to the survival of the WTO. For me, the core issue that has led to the impasse is that the two sides cannot compromise on their perceptions of China's trade behavior in the WTO. The US side, which are joined by the EU and Japan, has a negative perception of China's trade behavior in the WTO. China is a free rider, abides by the rules on a selective basis. China failed to comply with the WTO rules and commitments. The WTO rules cannot address the China-specific problems that the US believes China has brought with its unique economic model, which is often dubbed as the non-market economy. For China, there is no standardized market economy system, and moreover, there is no definition in the WTO of market economy, and the US accusation is not justified. In the eyes of China, the US is blind to the fact that China has integrated the international trade order after joining the WTO, and China is a true supporter of free trade and multilateralism. So given these competing perceptions, I think possibly we need to, as academic, we need to adopt objective approach. For China, I think it needs to admit that its trade behavior cannot live up to the expectation of the US side, but the US has to admit China is pursuing its interest and possibly maximizing its trade interest within the WTO system. Again, this background, two possible yet extreme scenarios which have been contemplated from time to time might not only be not advisable, but not the last resort against the background of declining WTO. That is, a US withdrawal from the WTO and a China expulsion from the WTO. So I think it's not necessarily to probe into the legal difficulty of a US withdrawal from the WTO and the legal possibility of China's expulsion from the WTO, for one to reach a conclusion that neither scenario is the last resort. That is, if we all agree that either scenario will represent a great loss and a serious threat to the stability of international trade order, I will argue for a WTO reform option. I argue in the first place a plurilateralized approach to the WTO. As an effort to save the dispute settlement mechanism, the establishment of multi-party interim appeal arbitration arrangement, MPIA, has indicated that a plurilateral approach seems to be an option for WTO members for the sake of ensuring the survival of the WTO institution. It's likely that more and more members will have to turn to the plurilateral approach in the foreseeable future, with a view to forging a plurilateral trade bloc among themselves or maintaining the WTO at a cost of universality of the existing multilateral trade agreements. Then I argue for a moderated reform agenda. It's for sure that no member is in a position to dissuade the US to give up its determination to reshape the WTO by introducing a set of rules that address the China-specific problems. And given that introducing a set of rules amount to nothing but targeting China's economic model, it's all understandable that a set of China-specific rules is not acceptable to China. A moderated yet integrated approach to WTO reform will be more suitable, if not as the only choice. Such reform agenda comprises a neutral reform agenda, maximize the use of existing WTO rules, prioritize the search for the way out of the dispute settlement impasse, continuation of the Doha Round talks, and the new rule-making power to keep the WTO relevant. So only by doing so, we can our interest can be maximized not only for China, but also for the rest of the trade body, trade community. Thank you.
Thank you.
Thank you.
Thank you. Interesting indeed, your presentation. As you say, it's a follow-on from what we had in the last session, where there was indeed a lot of interest in the current impasse in dispute settlement. Let's carry on now with Lee Tuthill. Lee's going to talk to us about process and progress, a readout on the joint statement initiative on e-commerce. The floor is yours, Lee.
Hi, thank you. Let me share my screen. Yeah, that should be it. Okay, you see that fine? Let me.
Yes, we do.
So I have to, there, I have to make it like that. Great.
It's next, it seems.
All right. As the title implies, I'll go a little bit through process because I think that's interesting. The e-commerce discussions have two tracks in the WTO. They have obviously a work program that began in 1998 and continues until today. And it is still relatively active, primarily looking at the issue of this moratorium on customs duties on electronic commerce, although its mandate allows it to discuss just about anything, and a number of other issues are on our plate. But the moratorium has dominated discussion for the last few years. And after the initial 1 or 2 years of the moratorium, when substantive discussions of the work program, when substantive discussions and very interesting discussions did take place, it's pretty much only looked at the moratorium related issues because every couple of years it needed to be renewed for ministerial sessions. And so far it has managed to be renewed. Unfortunately, what we have now is it's being called into doubt more seriously than ever before, particularly you see in my point, some papers by India and South Africa and some also a couple of other countries have some concerns they've voiced about developing countries needing the tariff revenue and other issues like that, how it's not in their interest perhaps. This is not a north-south issue per se. There's a lot of developing countries who also support the moratorium. But it is one that we are very concerned about what will be coming up for the next possible renewal of the moratorium. In fact, that's such a grave concern that not just one, but 2 workshops were held on the moratorium last year, mainly at the request of India. And we invited economists and academics to talk about their research in the area. And there were papers looking at all different aspects of the impact of the moratorium with various conclusions, both positive and one study was particularly negative. The other part of the work program is work in the so-called sub-bodies, and the work program was designed so that the TRIPS Council, Services Council, and Goods Council and the Committee on Trade and Development would all be part of the work program and report their discussions back to the General Council, which coordinated this. For the most part, sub-bodies, except for the Services Council, have not had a lot on their agenda for e-commerce for a number of years. Services Council was probably one of the most active for quite a while. As you know, the title of this talks about technology, the implications for services being 1, online, and being 2, technology-oriented services are enormous. And so the services delegations have always been very engaged in thinking about e-commerce. So that has remained relatively active. Now let's move to this joint statement initiative. As I said, it's potentially one of the most controversial of the various joint statement initiatives because of the two tracks. And because in the work program track, there were governments who did not
Excuse
want.
me, Lee, I think
Yes.
your screen has frozen because we cannot see the next slide. So,
Oh, well, I don't know what to do because I'm seeing it.
um,
I'm seeing it on my screen. You are sharing, it says.
Maybe you should change it to presentation mode, Lee.
What do you mean? I put it in
it is,
presentation mode on this.
it's that slide on the bottom. At the bottom, you can
Right.
see, yeah, there is that sort of slide.
Black, and
image.
this says toggle subtitles.
No, if you go a little bit more on the right, you can see before
Yeah,
the
there's a
size of the image. There is one icon which is
Yeah, I don't know how you're seeing it.
so it says display settings at the bottom, in the bottom banner. It says display settings, then there is one icon, there is one with 4 windows. There is
Right.
another one like a book, the next one, the last icon.
This one?
yes.
Yep.
Are you seeing it now? It says joint statement.
Yes.
It says process,
Uh,
Yeah, I'm
joint
seeing it.
statement initiative. Yes.
Okay. It looks very small on my screen, but maybe that's because of the setting I have. It's large enough on your screens?
Yes, it is.
All right. We have discussion basically for the last 2 years has been on text. They're no longer discussing the conceptual issues. They're no longer discussing various overall priorities and positions on various issues. They're discussing text. So it is a serious discussion. There is some talk about a market access complement, which I'll discuss again in a couple of minutes. And it has been very transparent and open to all members. I have to update 84 was the very recent figure, but as of yesterday and as of the very last meeting earlier this month, 2 more governments joined. So we now have 86 announced participants. But because the meetings are open-ended, there's very many WTO members who do sit in, and many of the members who haven't announced their participation also feel free to ask questions, of the proponents of the different texts and raise their concerns. So it's really 86 plus in a way, and they have discussed principles and text of principles under 4 main themes: enabling digital trade, which sometimes we call e-trade facilitation, openness of digital trade, trust, and cross-cutting issues, which are probably not being discussed is text at the moment. So let me move on to look at some of these. What I'm going to do is I've given you the grocery list of the different things here. I'm giving you substance, and what I'll do is as I go along, I'll talk about some of the things that may be somewhat more difficult or more controversial. A lot of things are going fairly smoothly, but text negotiations are very difficult. What we are getting as text in many cases is different governments' proposed text that is very similar, if not in some cases exactly the same as what they had in their free trade agreement or regional trade agreements, if you will, in their e-commerce chapters or e-commerce provisions. And so what you're getting is a certain degree of haggling over, well, why did you use this word and we use that word? And sometimes it seems that it was maybe substantive, sometimes it seems less substantive, and they're discussing basically each government's proposal for the exact wording of principles and provisions. It often is something that maybe on a given provision or sub-provision, you might have 3 or 4 different proposals, and then on another provision you have 2 or 3. It varies by proposal. And then people can make proposals from the floor as well who didn't put in an actual text proposal. In the area of customs and digital trade, I tend to call this area TFA Plus, or Trade Facilitation Agreement Plus. There's been a lot of discussion of issues that perhaps at some point people might have liked to see in the TFA agreement, but think that are perhaps more important for e-commerce now that we're looking at that. One of those, which is a bit touchy, is de minimis, which didn't make it through in the TFA. And I think to some degree, there are still some of the disagreements on doing de minimis rulings for customs. Facilitating electronic transactions, as you can see, tends to look at online payment solutions and processes for returns and transaction frameworks such as e-signatures, e-contracts. And this can draw, in the case of e-signatures, on some of the existing work of Untittled. Many governments already have legal frameworks in place for e-signatures, at least, which also can lead to governments saying, well, they want to make sure the text reflects the way they already do it. So it's not just because many people already have e-signature, e-contract rules or regulations in their country. It doesn't necessarily mean it's easier, but an awful lot of the issues are not terribly controversial. Customs duties on electronic transmissions, by default, you'll have people interested or positive about the moratorium in this particular group. Nonetheless, the issue on transmissions for a few governments is they're not sure they're ready to want to make it permanent, although the vast majority of governments in the group tend to be ones which would like to see the moratorium on customs duties made permanent. I'd say a handful of countries, including China, are doubtful if it should be made permanent yet. This other topic on openness and digital trade, there's a market access component, which is just beginning to be discussed. So we're not sure, where that will go yet. The good side of that is more or less taken care of, because the idea is to ask the participating governments to go over and join the ITA. So it would be ITA plus, if you will. Services part, that's more complicated, and they're beginning work on what kind of sectors would be the most relevant to e-commerce. They're trying to take a narrow view to avoid interfering or stepping on toes of the Special Council on Trade and Services, which would normally coordinate market access discussions and is still functional, was the Doha round body for organizing market access. Nonetheless, we have at least 4 proponents of services market access, and maybe sectors such as telecom, computer services, and logistics, various logistics and distribution services. And we'll see if some things might be added. Moving on to probably the most controversial or difficult part, challenging part, is the cross-border data flows and rules against localization of computing facilities or storage facilities. Tends to be obviously a more favorable view in this group than you might have in the Services Council. Nonetheless, I think it is an issue that is not, again, it's not a North-South issue. As big players concerned about their own mechanisms for doing this. Privacy is under a different topic, but it inevitably comes up in cross-border data flows talks in our group, because I think there are some governments who want a bit of a carve out for privacy from the cross-border data flow provision. Localization is in this particular group not perhaps as controversial. However, You know, as an IT person in the Secretariat, I am seeing more and more localization requirements going into place around the world. Do these satisfy some of the sense of exceptions that might be built into these provisions? It's hard to say until you see the provisions themselves. So their scope of exceptions is quite a difficult issue in this respect. There's a variety of, the next issue, access and non-discrimination, is a big variety of things, and the government, access to government data, access to networks, access to the internet for consumers, including businesses in general. There's some liability issues being raised on intermediary liability, which has been around for a long time. And let me just stop. The treatment of digital products is an issue that you saw historically in the American RTA's e-commerce chapter. And for some reason, it's not playing particularly well in the group. You know, it's a bit controversial as between the US and the EU. We hope that they can resolve differences, but the idea is it goes back to this old issue, if many of you may remember, of whether a downloadable book is a good or a service. The word digital products is being objected to because some governments and the Commission, European Community, for example, sees digitalized things as services and not as products or something other than services. So that has raised its head again. That has been going on for many years. And then we have a group of things categorized under trust. Source code is one of those. Technology transfer. Some of it is trust of consumers, and a lot of it, though, is trust of businesses as consumers, as businesses as suppliers of activities that are online.
Lee, could I ask you to close up in about 2 minutes so we have time?
Right, okay. And then again, you have consumer trust, which is more the consumer protection issues. It's not controversial, but there's a lot of text on that with a lot of proposals, so we're going through that. This is more or less discussions. I'll skip this slide. The kind of considerations that are sort of over everything is what kind of flexibilities may be built in for developing countries to participate in that. Would there be flexibilities a la TFA, like for the rules themselves, or flexibilities built into market access? And something that almost every meeting, and this process is very serious, they're meeting constantly, okay, in various configurations. Something that comes up again and again is at some point people want to check what they've done against the existing provisions of WTO agreements. That hasn't happened yet, but I think for people in the legal profession, that could have very important legal implications. And something that is basically not being talked about openly anywhere is the possible legal architecture, depending on what form people might want the outcome to take. There's 2 milestones now. The one is in December to present a draft and make it public sometime in December. If they achieve in doing that, there will still be brackets in the text, but it will be something that academics can look at, that governments can consult more openly with their private sector and other stakeholders. And then the next milestone would be the ministerial conference that was canceled this year that will supposedly take place sometimes next year. And both tracks will be coming in at that point with what can we do about the moratorium? Can we renew it or not? And a possible outcome of the joint statement initiative. And just, since you are a legal group, let me look at, this is the current architecture, if you will, of the WTO. This more or less shows the WTO Secretariat, but it reflects agreements. Can you see my little pointer? No, yes?
Yes, we can.
Various ideas going on as to whether as an outcome, if it stays in the WTO, which most people hope it will, would be built into the existing GATT or GATS. somehow by different mechanisms that could be used, or whether it will be a plurilateral like, you know, the Information Technology Agreement that is MFN consistent, even for non-members, or would it be a plurilateral outside that does not offer, like here, the Government Procurement Agreement, where you don't necessarily offer MFN to other governments? Those are sort of the kinds of things being bandied about if it is going to be part of the WTO system. There's also questions as to, you know, I think legal questions as to if it's a freestanding agreement, but yet it has intimate interrelationships with existing provisions, how will that work in the future? So let me end there, and so you'll have time for questions.
Thank you, Lee, for a very interesting presentation and overview of the Joint Statement Initiative and negotiations in the WTO. I'd like to give the floor now to Henry Gao. Henry's going to talk to us again about e-commerce and the JSI, particularly, I think, within reference to China. The floor is yours, Henry.
Thank you, Joanne. So I'm going to share my screen because I'll also prepare a slide for this. So, all right. So can you see my screen?
Yes, we can.
Okay, great. Thank you. So first of all, I'd like to thank BIICL and the organizers for inviting me. And I'm really pleased to be among the distinguished panelists, especially Lee, who was my mentor when I was working in the Trading Service Division 17 years ago. So this brought back the happy memories of working in the service division on the Mexico telecom case. And like what we did 17 years ago, I think today I'm also following in the footsteps of Lee, because she has really did a marvelous job of explaining to those people who might be unfamiliar with the GSI negotiation, what the whole negotiations is about. So instead of explaining the technicalities of many of the issues, I will simply focus on a few key issues relating to China. And actually, this presentation is based on a recent paper that I just finished, which examines in detail China's 3 submissions on e-commerce. So I posted the link here, feel free to download. But basically for today, I'm going to focus on 4 questions instead of covering all issues in the interest of time. So the first question is, what was the traditional approach China has on e-commerce in trade agreements? And second, why did China change its position and decide to join in the GSI? And third, what are the key issues and key positions of China in the GSI negotiations? And fourth, is the future deal possible between China and other WTO participants, especially the US, in the GSI? So if we look at the traditional approach China has on e-commerce, this is really heavily influenced by the unpleasant experience China had in this case in the WTO, the China publications case, which was a case that was decided by the appellate body 11 years ago. And this case basically touched on 2 key issues. The first issue is the issue of market access. If you have already included a specific services in your schedule, does that mean that you also agree to liberalize, let's say, the online delivery of these services? And China said no, but the panel and the appellate body disagree with China, applying the principle of technology neutrality. They said, well, so long as you agree to include a sector, you actually agree to open up these services, no matter how it is provided, including through online means. The second issue China had in this case is the censorship issue. So the Chinese has a censorship regime for audiovisual products and publications and now the internet. So the Chinese government was worried that the censorship was going to be challenged in this case. And it turned out that in this case, actually, the US didn't really challenge the censorship issue. Actually, the US even suggested that the Chinese government should do the censorship on its own rather than outsource it to some private firms. So the US appears in this case to be not challenging the Chinese censorship regime, which is very interesting. But still, this case, because China lost the case, so this case left some bad taste with China on the opening up of e-commerce of internet services. And that explains why China has been taking a really cautious approach on e-commerce issues in the WTO and also in the free trade agreements. So if you look at China's FTAs, so far there has been only a couple FTAs in which China touched upon e-commerce issue. And these agreements tend to focus on the traditional trading in goods facilitated by the internet or traditional electronic commerce issue, rather than focusing on the 21st century digital trade issues as you find in the US FTAs. So this also explains China's reluctance to join the GSI when it was first mentioned by a group of WTO members led by the US at the 11th WTO Ministerial Conference in Buenos Aires in December 2017. But when the negotiation was formally launched at the World Economic Forum in January 2019, China actually joined the GSI negotiation at the last minute. So why did China do that? Well, the official explanation, according to Chinese WTO ambassador, Dr. Zhang Jiangchen, is because China wanted to reinvigorate the negotiating function of the WTO and show up confidence in the multilateral trading system and economic globalization. But I think if you read between the lines of the statement, I think the true reason why China wanted to participate, because China realized that e-commerce is becoming another major issue in the WTO, and China want to make sure that it would participate in the rulemaking activities. Because before the GSI, we had the TISA, the Trade in Services Agreement, which was also led by the US, and China didn't join initially, and later when China wanted to join, China was repeatedly turned down by the US, so China did not want that to repeat. So this GSI, by joining it at the launch, China thought that it has an opportunity to now push China's own vision on e-commerce governance in the WTO. So since it joined the GSI, China has made 3 submissions, which were all issued last year in April, May, and September. The first one is more about laying the ground, and the last 2, the second and third, are more substantive submissions. So what are the key issues mentioned by China? Well, at the outset, China mentioned that it emphasized that the e-commerce should serve the purpose is development, helping the developing countries. And also it said the process should be open, inclusive, and transparent. So China basically wants it to be a transparent process that does not exclude any WTO member. Now, in terms of the specific issues, China emphasizes that we should focus the discussions on cross-border trade in goods enabled by the internet, together with relevant payment and logistics services. So why does China always emphasize that we should focus on trading goods enabled by the internet rather than the digital trade issues as emphasized by the US? Well, as I mentioned in another paper in the Journal of International Economic Law in 2018, the reason is because if you look at the e-commerce giants in China and the US, these tend to specialize in different things. Taobao, Alibaba, and JD.com, they tend to still specialize in the traditional trading goods, but it's just that it's done on internet platform, while major US internet companies like Facebook, like Google, they tend to focus on the pure digital trade. So that explains the different position China has taken on all these issues. And in addition to trading goods enabled by the internet, China also wants to promote the payment, the relevant payment and logistics services. So these would be since like the services provided by Ant Financial, which is going to have an IPO later this month, and also all these courier companies in China, which are fast developing also. So again, they reflected the nature of the e-commerce market in China. Now, China, as I mentioned earlier, wanted to focus on trade-related aspects of electronic commerce, and it doesn't really touch on the issues that is mentioned by the U.S. digital trade. Instead, it would focus mostly on the traditional trade facilitation issues, as mentioned by Lee earlier, which either are related to customs procedures or to the legal framework like the recognition of electronic signature, authentication, and electronic contracts. China also raising a proposal issues relating to consumer safety, internet security, and also development issues. With regard to the key demands of the US on free flow of data, prohibition of data localization requirements, and forced transfer of source code, China is not willing to engage on this issue. Instead, China said in its submissions, more exploratory discussions are needed before bringing such issues to the WTO. And especially on data flow, China said data flow should be in compliance with members' respective laws and regulations, which means that if a member for a certain reason like censorship want to control data flow, it should be able to do so. Now, if you look at China's two substantive proposals, many interesting issues are raised, but because of time, I'm only going to focus on one. Now, this is mentioned in the second proposal. It's called e-commerce related network equipment and products. What it does is to prohibit members from discriminating against the network equipment and products of any other member, and not to exclude such network equipment and products, not to prevent public telecommunication networks or their service suppliers from choosing them, and not to block the supply chain of e-commerce related network equipment and products, and so on. So actually, this proposal was tabled right after the US restrictions on supply to Huawei. So I would call this the Huawei Cloud. So as you can see, the Chinese proposal really reflect the interests of Chinese firms as they are facing all kinds of blockage issues in the world, either blockage of supplies or blockage of usage of Huawei equipment. But there has been some controversy surrounding this specific clause, because some members said this is more of a telecommunication issue, which should really be handled at the ITU, International Telecommunication Union. And also, even if other members agree to include this issue in the negotiations, I think it is still possible for them to block the Chinese equipment on the basis of a security concerns, by invoking the security exception. So quickly, last issue, is a deal possible in the future, given the vast differences between the positions of China and US? Well, here I would differ with most experts. Most experts claim that, especially given the differences on positions such as data flow and also data localization, it is simply not possible for you to have agreement. But I beg to differ. For example, if you look at data flow, now the two agreements which has the highest standard on data flow would be the CPTPP and the USMCA. But neither of these agreements actually promote an absolute right for data flow for its participants. Instead, what they said is only that the parties should allow cross-border transfer of information by electronic means when this activity is for the conduct of business of a covered person. So it has to be for covered services. So in other words, if China is not willing to liberalize the data flow for a specific services, it can just choose to not to include the specific services sector in its commitments in the first place. That will solve the problem. And second, data localization. Again, that has been a very controversial issue. Many people are saying China's strict regulations on data localization also made it impossible for China to agree on that. But again, here you need to look at the USMCA, for example. I mean, data localization used to be an issue in the CPTPP, but if you look at the USMCA, they actually solved this issue, because in the USMCA, the US actually brought over the ban to financial services sector by stating that the data localization should not be required so long as the parties' regulatory authorities for regulatory and supervisory purposes have immediate, direct, complete, and ongoing access to information processed or stored on computing facilities that are cover persons, uses, or locates outside of the parties' territories. So in other words, so long as the regulatory authorities would have immediate, direct, complete, and ongoing access to the information, it does not matter where you store the information. We will not require local storage of the data. So if that can satisfy the US regulatory authorities such as the Federal Reserve, I think it should also be able to satisfy the needs of the Chinese regulators. So just to conclude, I think that it is still possible to have some sort of agreement, and we just need to be creative in the negotiation on all these issues. Thank you so much.
Thank you, Henry, for that very interesting presentation, and particularly, of course, to hear the perspective of China on the GSI negotiations. We don't have any questions from the audience yet. I would encourage you, if you have questions, to ask them now. You can be first in the queue if you have a question. But in the meantime, I would like to ask a question myself. And in particular, I'd like to go back to Larry Kong, Professor Kong, and ask him for a few reflections on trade and technology and the role of China, if I may.
Professor Kong, you are still muted.
Sorry. Yeah. Actually, China has been quite innovator in certain fields of industry and technology, particularly, and for example, IT and e-commerce possibly has also leaders. So I think China is interested in being part of the rule making in this part. Of course, China certainly will safeguard its interest. For example, it's interested in localization of certain facility, and it's also interested in and the power of the state in regulate in a way free of flow of information in a certain way, and it's certainly interested in maintaining its ability of to it trade how can I say it's it's trade possibility of its trade of certain IT related products like Huawei certainly was has encountered a lot of obstacles which possibly were not in agreement with the WTO rules, and I think all these factors have been taken into consideration when China is participating in such negotiations. Even though I'm not an expert in this regard, but I do believe China will be interested and continue being interested in negotiation, and it will take whatever it takes to protect its interest. I presume. Thank you. Oh, so I cannot hear anything. Huh? Can you hear me?
I'm sorry, my screen seems to have disappeared, but I'll see if I can get back to it now. In the meantime, perhaps I could ask another question, and either Henry or Lee might wish to respond to this. I'm just wondering what lessons other developing countries can draw from the experience in e-commerce development. Henry, you might want to look at that in terms of China's experience. And perhaps Lee, you could also give some reflections on how developing countries have been involved in the negotiations so far. Thank you.
Yeah, maybe I will start with China's experience, and Lee can discuss the broader lessons. So if you look at the success of the Chinese e-commerce giants like Alibaba, they benefited basically from three things. The first is a platform, e-commerce platform. Actually, during the past few years, whenever I engage with the Geneva-based audience, many ambassadors and diplomats are very interested in China's experience, and they always ask if they can, for example, replicate the Alibaba platform in their country. And my advice to them is, well, maybe, but. The reason is that, Alibaba was able to succeed because it has a huge internal market, a market of 1.5 billion people, which is hard to get in many other countries. In most other countries, if you only have a few million people, or even if you have 10 million people, the domestic market might not be big enough to support a platform. So my advice, especially to developed countries in Africa, Latin America, and other parts of Asia, has been, if your population is not big enough, maybe you should consider having a region-wide platform rather than a country-by-country platform, because otherwise, the cost of having a platform would be too big. I mean, that is the experience that you see, for example, in Southeast Asia. For example, Southeast Asia has platforms like Lazada and Shopee, which are regional platforms. They have operations in several countries in Southeast Asia, in Singapore, in Indonesia, in Thailand, Vietnam, and so on, which are able to support and to defray the cost of maintaining the platform. But if they only operate in one country, let's say Singapore, it would probably not be worth their while. And second is the payment services, the rise of payment services like N-Pay. I mean, it used to be a problem facing the Chinese e-commerce players because most Chinese did not have a credit card, and this is still the case today. And the way they solved this problem was partly through technology and partly through the rise of mobile phones. Now, everyone has a mobile phone, and mobile phone basically provide a portal for them to access all kinds of financial services. And that is how Alipay and Ant Financial was able to become major players. So in that way, I think many developed countries also saw the hope to be able to leapfrog, to bypass the stage of having credit cards and proceed directly to mobile payment. But again, here, I think the tale is a cautious tale because, as I said, if you have a regional platform, then how do you deal with the issue of transfer of currency? If you have a regional platform like the case of Lazada, the headquarters in Singapore, but it operates in Malaysia, Indonesia, all kinds of different currency, can you really convert the currencies across the different countries? Well, that would be an interesting regulatory issue that has to be handled by the lawyers. And the last issue is the courier services. China was able to have all these courier services, which become really major players in the market that can face the global players like UPS and FedEx, because China has a really good infrastructure. The roads in China were very good. But if you look around the world, not many countries actually have the same level of infrastructure as in China, especially the case in developing countries. So this problem is partly solved by the Belt and Road Initiative, where China was helping many different countries to build the roads. But I think for them to match China's level would still be a long way. So again, I think my advice is to be more cautious rather than plunge in immediately. Thank you.
Excuse me, may I interrupt a little bit?
Yes, would you like to add something? Please go ahead.
Yes. I would like to add something to what Henry said. Actually, I think it was due substantially to the lack of regulation that Chinese tech giants prospered in the past decades. At that time, basically, there was no regulation concerning flow of information, and even there was no regulation concerning electronic payment. So that's why a lot of Chinese companies could take this advantage and develop as a big companies. now I think more and more regulations are being contemplated, even the rules are set forth. And so I think this possibly will pose an impediment to the development of new tech giants in other countries. That's also explain why China at the very beginning was not very much interested in taking part of negotiation of rules in this regard.
Thank you for that added reflection. Lee, I'll pass the floor now to you for some other.
Yeah, I just briefly, I tend to agree and disagree with Henry. On the one hand, I think everyone is looking for best practice or what are the practices that work and willing to compare notes. But the sense I get from the developing countries we've worked with through technical assistance is, particularly if they're smaller, and Henry acknowledged this, or if they're lesser developed, the goal a realistic goal will never to be one of the big players. So there's other objectives they're looking at, like export diversification, helping SMEs export more. In some countries, it's the services side, expanding their IT software and computer services, exports online, remote, providing services remotely. But I think that in that case, they want to succeed on their own terms, rather than necessarily say, well, I might as well give up if I can't be a China or if I can't be a US. So I think that there's a lot of enthusiasm in individual countries, even sometimes least developed countries, on the ground. A lot of it is experimentation going on in the domestic market, as small as it may mean, but they're cutting their teeth in the domestic market in many cases. And I once thought that the external market would come first and the domestic market later, but there's been enough access in domestic markets through mobile phones that I think the domestic market surprised us and grew first.
Okay, thank you. Thank you, Lee. We now have a question from the audience. I think you can see it on your screen there. A question for Lee, and it's from Spiros Maniatis asking, what is the role of IP ASI?
Well, I'm sorry, I don't have a very good answer for you. The work program, the TRIPS Council looked at all of the provisions, and of course the conclusions that were never formally reached was that the TRIPS agreement is there for countries. There has been only one proposal that is IP related, and I think it was by Brazil. I'm not sure people know quite what to do with it, because the question is, can what the JSI do somehow amend the TRIPS agreement? But there has been one proposal mainly, and it hasn't really come up in a big way yet. I think people are struggling with, should this be dealt with more in the TRIPS Council perhaps than the JSI? But I'm partly guessing there. It's mystified some of the players a bit as to what to do with an IP proposal.
Okay, thank you. We still have a couple of minutes before the end of the session, so I'd just like to have one more go around and see if the presenters would like to add anything else. Oh, just a second, I see we have another question that's just come up. No, it's just in response to what we just had. So Henry, any final reflections for us before we close the session?
Yes, actually, I will reflect on something that Professor Kong mentioned, the tension between the US and China and its implications on the GSI e-commerce negotiations. With the rising tensions, many people are becoming more and more pessimistic that a deal is possible between the US and China. But I think there might still be a silver lining to the ongoing dispute, because what you saw is that the US started to have more and more restrictions on Chinese tech firms, like the recent restrictions on TikTok and also WeChat. And maybe these US actions, I think, could be a wake-up call to China, because when they saw that other countries could replicate the same kind of restrictions that China has been imposing on firms like Google, Facebook, maybe China would rethink its approach to internet regulation, and maybe China would try to adopt a means that is less trade restrictive than the simple ban it had in the past, banning the full app or the website, and adopt a more sophisticated way of censorship. Maybe that would be something that could help a potential deal in the GSI, especially on the issue relating to free flow of information, and also on censorship, and also the security and the public moral exceptions issue in the GSI. So I'm just thinking out loud. Of course, I don't have the crystal ball, but I do hope that this provides people with the opportunity to rethink all these issues. Yes, thank you.
Thank you, Henry. I'll just then ask if the panelists have any final words they'd like to add before we close the session.
I'd say just a very brief statement. I think part of the discussion at this conference as a whole is about, the future of the WTO and the trading system. And there are people who believe that this approach taken in this JSI and other JSIs is a sign of the future, a way the WTO could remain relevant. I think that's true up to a certain point, but I'd only point out that going back many decades, plurilateral configurations have always been part of the WTO, where people brainstorm and work on ideas, and hopefully in many cases ultimately multilateralize them and gained acceptance by other members. I mean, in the back rooms, that has always been the process, that things start maybe small and get bigger. Institutionalizing it is perhaps maybe what people are referring to, and how the GSIs may be a mechanism that can help the WTO succeed. But again, there are some people who think these GSIs shouldn't exist, so it's a bit controversial.
Okay, thank you. I think our time is more or less up, so I'd like to close the panel now. I think it's been very interesting, particularly to have the Asian perspective on the JSI, and also the perspective here from Geneva. So I would thank the panelists for their contributions, and the audience for their questions. And I'll give the floor now to Julinda.
Thank you very much, Jan, for the excellent chairing of this panel. Thank you very much to the speakers for the insightful presentations and the discussion. We will now have a short break, and we will meet again at 11:30 London time. Thank you very much.